Hi, this is Jen Rubin, editor-in-chief of the Contrarian. So happy to have back with us Andrew Weissmann. Andrew, welcome back.
Thank you. I wish it was on a topic that was less dire, but I totally understand why we're doing this.
Exactly. So the meeting in the Oval Office, in my view, outdid the meeting between Trump and Zelensky, because here you had the President of the United States sitting next to a real dictator, a wannabe dictator next to a real dictator. In essence, playing a game with someone's life, refusing to do, in essence, what the court suggested, the Supreme Court suggested, which was to facilitate the return of a man who had mistakenly been sent to El Salvador to be held in this hellhole of a place. And you had these two leaders gawking it up, guffawing it up. And it was very apparent that Trump in no way wanted to do what the court had told him to do. Where is that legally? And what's the next step in terms of trying to get this poor man, Kilmar Abrego Garcia, home?
Sure. Well, there's going to be a court appearance this afternoon in the district court, which has now been given her marching orders by the Supreme Court, as has the government. And the district judge, she has been trying valiantly since the ruling to find out answers to specific questions. But the key is she wanted to know what efforts has the government taken to do what the Supreme Court ordered? The Supreme Court ordered two things. One, that the government must facilitate his return to the United States. And two, they must ensure that he be given the due process rights that he would have had he not been unlawfully and improperly removed from this country. And they have to do these daily reports per the district court order. And I couldn't agree with you more with respect to what we saw in the Oval Office. As we were just chatting about, it's a bit of an Alphonse Gaston routine where I like to boil this down to sort of brass tacks. I'm like a very concrete thinker. Here's step number one that the United States government could do in any situation, even where you had no prior agreement with another country. Here, of course, they did. But here's step number one. Have you asked for his return? In the Oval Office meeting, no reporter, no conversation was basically saying, not basically, no one was saying, can you return him? Jen, imagine that you had caused the unlawful and improper removal of somebody to another country where they are imprisoned. And the simplest, the easiest baby step is, will you return him? In the Oval Office, you had this bear hug of like autocrat to autocrat or would-be autocrat to autocrat, where they're, as you said, yucking it up. The President of the United States is talking about, can you build more prisons to hold more of our people, including Americans? This was not an adversarial relationship. By the way, note to self, the president of El Salvador was not wearing a tie. Didn't notice that when he is an autocrat not wearing a tie, that's fine. When you have a hero, a democratic hero, one of the true heroes of our lifetime, that is something that's called out by a Trump loyalist. So this idea that there isn't an agreement between countries and we're paying for these people to be housed there, the idea that we don't have the ability to A, ask, or B, have leverage to bring him back is just fanciful. And all of the rest goes away. I mean,
Yeah.
that is why there is contempt of court. That is why this is completely lawless, and that is why it's completely cruel. And so what's remarkable is that you not only had Donald Trump engaging in this show, but he's doing it with an autocrat. And then, unlike Trump 1.0, Everyone else is towing the line. There's no pushback, including from the Attorney General of the United States, who is sitting there, who knows what the Supreme Court has ruled.
Right. And in fact, an abject lie saying, Stephen Miller saying 9-0 in Trump's favor. No, it was 9-0 against Trump, that they have to give this man due process. Now, a couple things. First of all, the president of El Salvador sort of let the cat out of the bag, frankly, when he said we would have to smuggle him back into the United States. That suggests that the problem is with the United States, because you only have to smuggle someone if they're preventing you from returning him. So, question about that. The second question I come up against is that the administration seems to be arguing two somewhat contradictory things. One is you don't get to tell us what to do, meaning the court doesn't get to tell us what to do on foreign policy. And in fact, they have nothing to do with foreign policy. They're telling them what to do with respect to an individual who enjoys constitutional rights that we have improperly shipped. And the second thing they're saying is that, well, we can't get him anyway. So which is it, that they are being told to do something that we have no right to do, or they're weak and impotent and they can't possibly achieve this outcome? These things seem to be in contradiction. What, if anything, can the judge do to kind of untangle this and give them a single clear directive that they will find difficult to evade or ignore?
So I view this as very much an issue of fact, not a legal issue. There is no question that in a completely different factual circumstance, where the United States has tried to bring somebody back from an adversarial country, let's just say Iran, and Iran's saying, no, we're holding them hostage and we're not returning them, and the United States has tried. The courts don't have a role there. And there's a limit on what the courts can do, even if the government has somehow mistakenly caused that to happen. The courts can do what this, and the Supreme Court has ordered it. They can facilitate, they can try. There's steps that they can take to bring him back and accord him then the due process rights. But ultimately, the courts are not going to dictate sort of foreign policy or the exact means. But we're not in that situation. It's a factual call where the Trump administration wants us to believe, in spite of saying they're all powerful and they can dictate to the world on all sorts of things, including tariffs. They can dictate to the world, including law firms, including universities. But when it comes to El Salvador, somehow, even though the president of El Salvador is in the Oval yucking it up, somehow they want us to believe this is some adversarial relationship when they haven't even said to the court, return him. We'd like you to return him, which of course they would do. And by the way, if you don't, we're not paying you for any of this. So we're just not in that legal quandary of they've done everything they could do and they're not required to do more, and the courts don't have a role. And so the factual issue then is, if they want to say it's El Salvador's problem, and El Salvador wants to say it's America's problem. One, I think El Salvador is right, which is El Salvador is saying, look, essentially we can release him, but like we can't get him to the United States without the United States agreeing, meaning we can't smuggle him in. That seemed like a right answer to me. But that is not then. But of course, the America took that to be, oh, no. See, they won't release him, and we're stuck with that answer, which that's just a lot of, I don't know, let's just take President Biden used to say, a lot of malarkey. And I'm sure there are other phrases one could put in there if this was not a PG show. And that's one where the district judge and the plaintiffs are trying to get the facts. They have the plaintiffs have asked for, what are the written agreements? What is the payment schedule? What is the understanding between the two countries? You don't send all these people there to this prison. You don't have Christine Noem go there without a basic understanding of the agreement and the terms of the agreement and how much we're paying them and where does the funds come from to pay them. All of that is something that the district court can and should be able to do. She should be able to call for a hearing. And if people do not show up with personal knowledge, she can hold them in contempt. She can also use the unwillingness as a fact against the government. In other words, when you are in contempt, you can draw adverse inferences that the reason you're not doing that is because the answers would be adverse to you. On the podcast with Mary McCord, I gave an example of what the judge can do, which is to draw an adverse inference. In other words, if there's stonewalling by the government and the court says, look, did you just even ask? What is the relationship? What is the written agreement? She's entitled to draw an adverse inference. Beryl Howell did just that as an example in the case where Ruby Freeman and Shay Moss sued Rudy Giuliani, and he kept on violating the discovery rules and wasn't turning stuff over. And the judge said, look, if you continue doing that, I'm going to draw these adverse inferences against you and direct the jury to draw these adverse inferences. And he still was not in compliance, and that's what she did.
Right.
And so that's a way of trying to deal with this kind of contempt. She also has contempt power. I mean, a lot of people have asked the question of like, what can happen here? And she can hold the government in civil contempt that can include fines. If she thinks that somebody is doing this willfully, she can actually even put them in jail until they cure the contempt. If it's a lawyer, she can refer them to the bar. She can disbar them from the court bar, but also just in general, she can refer them for that kind of contempt. All of that is civil in nature. And there is even some law that allows the court to bring a criminal contempt prosecution. And some people will say, well, who's going to prosecute that? Because Pam Bondi's DOJ is unlikely to do it. And in the Southern District of New York, Judge Kaplan, Lewis Kaplan, people may remember him from overseeing the E. Jean Carroll cases, among many other things. He actually appointed a prosecutor, and there is authority for the court appointing a prosecutor in the context of criminal contempt of a judicial order, as part of the inherent authority of the court to vindicate its rulings.
That the sort of kind of I don't want to call it tough love, it's just toughness that perhaps is needed. Chief Justice Roberts was so deferential to Trump in talking about facilitating, in taking that with the greatest deference to the Chief Justice. Maybe he didn't realize how far that Trump would run with that. Now you have a judge who is actually being defied on multiple levels, even something as simple as filing the information they are supposed to every day to inform the court. Is that, do you think, what it's going to take? An absolute contempt ruling, which will then get appealed back up. And eventually we're going to have the Supreme Court, cut or fish bait, decide, are they going to require the President of the United States to abide by the court's decisions?
We are at that moment, yes. And I don't know what was in Chief Justice Roberts' head. I'm assuming I like to assume good faith when I can. If you assume that he thought that the Department of Justice doesn't act in a way that is blatantly contemptuous, and that the signal from the Supreme Court was clear enough, and I would say in any other administration, it would be. I've served under Republican and Democratic administrations. The Attorney General who signed my certificate, which I have on the wall here, is Bill Barr. And it's just not imaginable that in any of these situations that you wouldn't have full compliance. And if you thought there was something that got legally wrong, you might ask to re-argue, but you just wouldn't engage in this kind of behavior. And so you have to assume that at least that they thought that this would be sufficient. And that's one where, this is fool me once, shame on you, fool me twice, shame on me. And so we are at that moment where the Supreme Court, it will end up back there because we're not seeing what any normal administration would do in this situation. And in fact, we're seeing kind of the opposite. You alluded to Stephen Miller's comments, which is blatantly mischaracterizing what the ruling is. You have the Department of Homeland Security putting out a press release that's now trying to rebrand Mr. Garcia in a way that's just not supported by the record, saying that he is a terrorist and an MS-13 gang member. I should point out that the Fourth Circuit in this case said there was no evidence, that's a quote, no evidence that he is an MS-13 gang member. And as I've said to you, Jen, even if he were, that has nothing to do with the law point here. The rule of law is tested when you're dealing with people who are not popular, who are accused of doing heinous things, and they're still entitled to due process of law. And so for the administration to use that to try and win the hearts and minds of the public, when in fact, legally, they're supposed to be standing for the proposition that everyone is entitled to due process, and the government has the obligation to prove that. And by the way, they have a forum to do it. This is sort of, Nicole Wallace keeps on saying this. All of this is so performative because if they really thought he was a part of a terrorist organization, they have a means to go to court, prove it up, and remove him legally, and
Exactly.
complying with all of the due process that someone is entitled to. And the Supreme Court has said they're entitled to in a separate ruling.
Exactly. Even someone who is accused of 34 counts of criminal conduct under state law in New York deserves due process, deserves the benefit of the doubt multiple times. So,
And got it. And got it.
and got it beyond, above and beyond, frankly, what any other normal individual would be. Well, thank you, Andrew. And I want to emphasize 2 points as we say goodbye to our audience. The first is that due process is meant for criminals and for the accused, for the innocent, for the guilty. That's why we have due process. And secondly, there's a point at which we may not want to admit it. It may not be politically convenient. People may not yet be ready to protest. But this president, this administration is acting in contempt of court. It is acting in ways that are deliberately designed to thwart the courts, whether it's not following the ruling to allow the AP back into the Oval Office as part of the pool, or whether it's not filing a report they were told to do, or it's not facilitating. All of these, whether you like it or not, whether we want to acknowledge it or not, they are violations of court orders. This is entirely lawless. And the question is, for our democracy, whether we're going to be strong enough to force, if necessary, that confrontation and decide whether we're a country of laws or whether we're going to let Trump and his lawless gang of thugs take us down a path in which anyone can be chucked into some foreign prison. So it is definitely, as you said, we're at that point, Andrew. So thank you once again for joining us. Thank you for your knowledge and wry humor at times, which keeps us afloat and keeps us from spiraling into complete despair. So thank you. We'll look forward to having you back again soon.